Greetings, everyone. Why don't we go ahead and get started? I know people are trickling into the room, but let's get on with the exciting program. I know you're joining us from all over the world. I'm Catherine Amirfar. I'm president of the American Society of International Law, and it's my great pleasure to welcome you to the Midyear meeting and to open our 10th Research Forum. So over the next 2 days, the Research Forum will explore the most exciting new work taking place in international law, with expert-led discussions of papers on a broad range of current and emerging issues. I want to extend my warmest congratulations to the presenters whose papers have been accepted for these sessions. And I'd like to thank our wonderful Research Forum Committee, chaired by Kathleen Clausen, Veronica Fickpack, and Ben Heath. They've devoted an enormous amount of time and effort over the past 6 months to make this event a reality. And together with committee members Arturo Carrillo, Kabir Dugal, Paolo Farah, and Rekha Rangachari, they reviewed the abstracts, selected the papers, and organized these expert-led panels that you'll be attending over the next 2 days. I know we can't clap for them, but please join me in thanking them for their outstanding work. Before turning to our opening roundtable, it is my great honor to join in announcing the winner of the 2021 David D. Corin Prize, which is awarded to the best paper presented at the Research Forum by a current student or recent graduate. The prize honors the memory of David Corin, who we know as a distinguished international judge, lawyer, and a natural-born and inspired teacher. David was also a beloved friend and colleague who loved the society and served as president from 2010 to 2012. David created the Research Forum during his presidency, and it remains a very important part of his legacy. In 2018, the Society created the David D. Corin Fund to support, enhance, and perpetuate the Research Forum. The fund supports fellowships to enable younger scholars to participate in the forum, as well as a prize we're about to award. I'm so happy to say that David's wife, Susan Spencer, will once again be with us to announce the winner of the 2021 David D. Corin Prize. Susan, over to you.
Before I announce the 2021 winner of the David D. Corin Prize, I would like to express my gratitude for those who made it possible. While David saw the need and opportunity for a research forum at the ASIL mid-year meeting, it took the ASIL community to bring it to fruition and to maintain its relevance. Thus, I thank the committee and the ASIL staff for their outstanding work on this year's virtual mid-year meeting, and I thank the up-and-coming international law scholars who submitted papers. The David D. Corin Prize exists thanks to the generous donations of David's colleagues, students, friends, and family. A special thanks goes to Charles N. Brower. And the prize winner couldn't be announced without the work of the Corin Prize Selection Committee. Thank you, Angela Banks and committee members. I'm happy to announce that the winner of the 2021 David D. Corin Prize is Cori Krebs for her paper, The Effects of Visual Evidence on the Application of International Humanitarian Law, a Behavioral Approach.
Thank you, Susan, and a huge congratulations to Professor Cori Krebs. For those of you already checking the agenda, Sherry's session is scheduled for today at 1:15 p.m. Eastern Standard. I want to express my own appreciation to this year's Corin Prize Selection Committee, chaired by Angela Banks, with members Arif Ali, Adejoke Babington Ashai, Katerina Asanova, and David Sloss. So please join me in thanking them for their amazing work. And now to the roundtable. It's my privilege to introduce it. It's on the regulation of online speech, Facebook, artificial intelligence, and the future. Obviously, really small topics for us to be taking on this morning. So October marked the 1-year anniversary of the operation of the Facebook Oversight Board, and its work has been closely watched by experts in cyber law, free speech, human rights, and security. At the same time, conversations about the role of AI in managing online speech have become more urgent as politicians around the world consider regulatory actions towards global online service providers. We're privileged to have an absolutely superb group of speakers for this roundtable discussion joining us on efforts to regulate online speech and the political and legal developments that will shape the future of online communication. I'm so happy to give the floor to our moderator, Professor Anupam Chander of Georgetown University Law Center, to introduce this session and the panelists. Over to you.
Thank you very much, Catherine, and thank you and Mark for your tremendous leadership guiding the society during the pandemic. I was also really touched to see the David Caron Prize awarded by his wife. You know, David was a lovely person and a dear friend, as you said in your opening remarks. So it's wonderful to see him honored and remembered this way. So it's my great pleasure to kick off this exciting mid-year research forum, and to kick it off with such a great group of experts to discuss really one of the kind of hot topics in international relations and international policy, which is the regulation of online speech. So we've seen a tremendous amount of kind of interest across the world. We've seen, that's my coworker who is kind of making his presence known here. Sorry about that. We've seen a tremendous interest in this, especially due to the release of what has been dubbed the Facebook Papers by Frances Haugen, who is a whistleblower within the Facebook organization. And we saw her testifying this week at the European Parliament, and so she's going around the world. You know, she's invited across the world to speak to policymakers. So we've seen the tremendous interest across the world in what she's suggesting in kind of the papers and her arguments about possible reforms. She suggested, for example, that the Digital Services Act in the European Union might become a global gold standard for content regulation in some sense. And so, kind of very interesting sets of questions about how to proceed with regulating internet enterprises that, of course, span borders. Sorry. So, I'm going to introduce each panelist as I ask a question to them, but I'm going to ask a set of questions to them, basically about a half dozen questions, and then I'm going to turn it over to you. And so the audience really is invited to participate by using the Q&A function. Really just, start teeing up your questions as they speak, and I'll try to get through as many of them as possible during the ample time we've left for Q&A. The first panelist and expert I want to turn to is Christie Edwards. So Christie Edwards is the deputy head and acting head of the Tolerance and Non-Discrimination Department of the Office for Democratic Institutions and Human Rights at the Organization for Security and Cooperation in Europe, the OSCE. She was previously the Director of International Humanitarian Law at the American Red Cross. And most importantly for our particular group, she is the co-chair of the 2021 annual meeting. And so, I'm very excited to welcome her to this discussion. Christie told us this morning that she is in Poland, and there are kind of controversial protesters marching outside her window right now, exercising free speech in a very controversial way that would be regulated in some spaces, in some countries, and not in others. So I'll be interested to see if Christie wants to touch upon that at some point in the course of her remarks today. But Christie, you've been working with several tech companies trying to deal with discriminatory and harmful online information. What have you learned about the challenges here?
Well, thanks so much, Anupam, and to ASIL for inviting me to join you today. And I only wish that my coworkers were nearly as cute. So maybe just to start with a little bit of the legal framework, and I guess I'm here in the international organization's very much 30,000-foot view perspective. And while the OSCE is based around a number of political commitments, obviously the international legal frameworks do apply. And so what we often talk about in these spaces when we're having conversations with tech companies as well as local communities is some of the universal documents that do apply here. And the UN Human Rights Council has affirmed that the same rights that people have offline also need to be protected online. And so the protections for human rights and fundamental freedoms need to be adhered to independent of the technologies that are applied. And so as social media platforms are using biometrics, facial recognition, and artificial intelligence, this can have some serious implications for the enjoyment of a whole range of human rights and can have a chilling effect on the right to freedom of thought, conscience and religion, freedom of expression and opinion, the right to freedom from discrimination, and the right to not be subjected to torture. As AI technologies also reflect the values and the choices of the people who build and use these technologies, they've also been shown to be prone to bias and discrimination based on ethnicity, gender, income, appearance, age, religion, behavior, or other attributes. And we also, of course, saw during the COVID-19 pandemic that this further exacerbated pre-existing discrimination and intolerance and fueled the rapid and global spread of online anti-Semitism, including incitement to hostility or violence, conspiracy theories and scapegoating, of course, the age-old disinformation about Jews and other communities, and it accelerated the rise of Holocaust denial and distortion, amongst many other horrible things towards other communities, particularly people of Asian descent, of course, as well. So I would say, as a starting point, more efforts are needed to tackle these phenomena in ways that are compatible with international human rights standards and stand up to these challenges that are posed. Maybe just as a quick statistic for folks to think about, a recent report showed that 84% of posts containing anti-Jewish hatred were not acted upon by social media companies. And when we're looking at Facebook in particular, they didn't act on 89% of those posts. And I would say while my department covers a wide variety of issues for different communities, we often see that that intolerant discourse, hate speech, and targeting of Jewish communities is frequently sort of a bellwether for targeting of other communities as well. So they're very much interlinked. So some of the civil society organizations that we've been speaking with have raised a number of concerns regarding, number one, the ability for tech companies to regulate online content, but also concerns about the overregulation, which has led to the creation of numerous legal frameworks nationally that don't always fulfill the obligations under international human rights law. And so they frequently recommend that increased transparency is needed from both companies regarding their policies, as well as from states in their legal frameworks and rulings. They also suggest that social media companies be more transparent about how they moderate and curate content, their processes and community guidelines, as well as information around due diligence, redress, human rights impact assessments, and ways to appeal content moderation decisions, among other issues. Another issue is the lack of transparency in the disclosure of government requests for content removal. And they recommend that states should be more transparent on their requests for content removal and avoid passing legislation that prevents companies from disclosing government's requests for user data or content removal. And then finally, they should prioritize the protection needs of those in vulnerable situations, such as minorities. And it's really critical to address and engage with the main targets of online hate in order to protect these populations. This protection would allow for heightened agency for these groups, and additionally, access to online connectivity and media and information literacy are big priorities for many of these groups, which is critical for advocating for human rights and resilience and the empowerment of private users. And they also recommend that it should be provided by states in partnership with social media companies. So I'm happy to go into some of the tools and resources that we're working on maybe a little bit later in this discussion.
That is a terrific set of suggestions for how to improve things. So thank you so much. I really appreciate the way to kind of kickstart this discussion. So I want to turn to Mukund Rathi, who is, I think he's kind of slotted for the next Eternals 2 campaign, as you will see shortly, and should be clearly one of the next Eternals. But let me kind of introduce his background here. Mukund is a lawyer and Stanton Fellow at EFF, the Electronic Frontier Foundation, focusing on free speech litigation. He previously worked at the National Association of Criminal Defense Lawyers on digital privacy rights in criminal cases and securing freedom for incarcerated people during the pandemic. Mukund, so after the Facebook disclosures, many have suggested statutory reforms in the US in response. So let me identify a few reform proposals quickly. So one of them is to modify Section 230 so it doesn't cover algorithmic amplification, create online safety and other content regulations, perhaps modeled on the EU's Digital Services Act, treat platforms like common carriers that have to carry speech unless it's illegal, enact a national privacy law. What do you think about these approaches? Is any of them promising?
Thank you, Anupam, for the introduction. My work at Regiment's not intense enough to be in the Eternals. I wish it was. I wouldn't have time for panels like this if I was working out 4 times a day. So I think, on the one hand, it's definitely refreshing to see Facebook kind of get what it deserves in the public discussion, and to face some real scrutiny in Congress after what feels like years and years of them failing to enforce their own policies, them spreading misinformation, and then just harming internet users and their own users in so many different ways. And you would hope that when a business does pretty bad and well-documented things like Facebook has done, it would get that response both from consumers, people who use its services, and then also from regulators. But it seems like they've gotten away with it for a very long time. And so it's nice in some ways to kind of see that pressure and that discussion change. On the other hand, I do have, and EFF does have a lot of concerns with some of the proposals that have come out of this latest scandal. And I think it's worth putting in context that the tide has already been shifting in a lot of ways. I mean, right now, Facebook, for example, is facing lawsuits in the US over its business practices. I think one of our big concerns is the way that companies like Facebook, Google, other big tech companies in the US control so much of the internet, and they've been allowed to grow in ways that are probably can be described as monopolistic and probably violate antitrust laws in the US. So right now, Facebook is facing legal scrutiny over its acquisitions of other social media or other internet messaging companies like WhatsApp and Instagram. Instagram, for example, and a lot of these things are still allegations that'll have to be proven in court. But there seems to be pretty good documentation that Facebook internally said, hey, Instagram looks like it's going to be a real competitor to us in this photo sharing space that we want to be more involved in. So let's acquire them rather than compete with them. Let's acquire them and leave users of that platform with no other option but then to join that kind of Facebook universe. So that's one thing that I want to suggest is that I think the tide has been turning in a lot of ways in the conversation on big tech and on social media and its effect on the national discourse, its effect on privacy and free speech and all of those things. So in some ways it's concerning actually the new direction the conversation is taking, because I think the conversations we were having around antitrust reform were, and I think will continue to be, pretty promising. So to turn to the specific proposals that Anupam mentioned, for example, let's take like regulating algorithmic amplification or other use of algorithms. It's understandable on the one hand to look at what Facebook has done, the way it's amplified misinformation, and say, hey, we should regulate that. I think there's 2 criticisms I would make, or at least 2 cautions I would put out, one of which is legal and the other is more about public policy and what would be good for people. On the legal side, the First Amendment in the US, which protects freedom of speech and freedom of expression, does apply online. And we should be happy that it does, because that means that us as users of the internet have free speech online. But equally, it does apply to entities, people or entities or companies, whatever, who create social media platforms. And the same rules and a lot of the same constitutional rules at the very least that apply to Facebook should apply to everybody. And that's both for our benefit and just both for the benefit of having a consistent legal system. So rules that regulate algorithms or regulate amplification is, I mean, how do you distinguish between a social media platform like Facebook amplifying certain types of speech and someone amplifying other types of speech on their personal blog post, on their website? You know, when we talk about social media platforms and regulating them, we're not just talking about Facebook. We're also talking about Roblox, which is a really, you know, fast-growing and popular video gaming social media platform. We're talking about Strava, which is a popular platform for athletes. And we're talking about, I mean, there's all sorts of random websites for, you know, different political groups, different cultural groups. We have to be, you know, thoughtful that the rules that we're applying that may restrict free speech are going to apply across the board. So that's why I'm skeptical, just to take that example. Another one you mentioned was maybe content safety regulations modeled after the European DSA. I'll admit I'm not an expert on the DSA. You know, people in my organization are working pretty hard on that. And I'll actually, once I'm done talking, I'll drop a couple links in the chat about what some of our folks have written on it. You know, I think there's some good parts of the DSA. The content safety regulations, for one, pose some of the same concerns as far as free speech goes. And, you know, I know that this is something that's different in different cultures and in different countries. We have different approaches to deal with hate speech, to deal with offensive content online. But, you know, the experience in the US, I think, and in other places can fairly show that putting the government in charge of regulating what people can and can't say, even when we consider certain things to be offensive, creates a lot of problems. For one, the DSA contains, or I mean, at least some of the proposals being considered contain really strong regulations requiring platforms to implement automated copyright filters. And copyright filters, you know, we've seen across the world, especially in the US, are basically a way for big businesses to prevent users from not just violating copyright, but also producing their own content, which may include in some ways a bit of music from you know, something that's copyrighted. In the US, we have a fair use regime where to some extent you are allowed to use copyrighted works when you're creating your own content. But even here, we still have a really big problem on, you know, what comes to mind is a platform like YouTube, where all the time content creators are putting out material, their own material that makes fair use of copyrighted material, but boom, you know, YouTube takes down their content because of an automated filter. And sometimes the platform will come back and say, hey, we made a mistake. You know, we should not have taken this down. That only works when platforms have workable appeals processes in place, kind of what Christie was mentioning earlier. You know, some standards that I think platforms should follow, but that raise tricky questions when we start empowering the government to require them across the board. And then I think, again, not being an expert on what's going on in the EU, I think, you know, you also have to keep in mind that like in the US, I think the conversation in the EU was in a lot of ways going in a good direction. I mean, GDPR is still for privacy experts and for folks at the EFF, GDPR is still the gold standard in a lot of ways. And the GDPR has restrictions on what automated decisions platforms can take against users. And I think that's a good caution and a good guideline to have in place, and one that I would, you know, it'd be disappointing to see that taken down. Anyway, I've talked for a little bit. I know that there are a couple more questions, but I want to make sure that I leave time for Corin to jump in also. Anupam, I think you're muted.
Yeah, sorry. So let me turn to Corin. Thank you so much, Mukund. Let me introduce her first. Cori Stone is a fellow at American University. She's currently on leave from the Office of the Director of National Intelligence, the ODIHR, which she helped stand up and for which she served as the principal deputy general counsel. Ms. Stone served also as the executive director for the National Security Agency, the NSA, from 2014 to 2017. I just want to point out to the audience here and the EFF audience in particular, that is post-Snowden revelation. So, important timetable here. And she also previously served as the attorney advisor in the Office of Legal Advisor to the State Department, and also served for 8 months in Iraq. So, Corin, we've already had mention of AI. Both Mukund, sorry, hold on. I'm being attacked here by my dog. And Christie discussed the use of AI moderation systems. So what are some of the your thoughts about the use of AI in content moderation? Is it necessary? How do we deal with its failures? What do you think?
Yeah, so I think on the surface, the benefits of AI seem quite obvious. Of course, it can scale to large volumes. It can prioritize and sort the most important content first. It moves much more quickly than a human, so it can theoretically stop harmful content before it proliferates too far. It also would allow human moderators to avoid having to look at all the content, which is sometimes traumatic. And it's consistent with how it's trained. So it will execute precisely over and over and over thousands of times, given how it's trained. But there are significant limitations, some of which Christie and Mukund touched upon. First of all, I don't think we can take those benefits that I even just mentioned for granted. There's a threshold question whether artificial intelligence technology is even good enough to provide those benefits at the moment. If we assume that AI is 99% accurate, which would be fantastic, given the volume of data on the internet, is 1% of the internet even still possible to look at with human eyes? It's enormous and overwhelming. We know there are hundreds of millions of uploads a day, probably to Facebook alone, but across all sorts of social media. And so do we have enough humans to even look at 1% of that? So I think there's a very real question in terms of, is AI even good enough today? But while we have that question, I think if we're going to assume there are benefits in trying AI and using AI to at least sort through some of this, there are other real limitations that I think come into play, again, some of which have been touched on. First, I would say, is the definition of what should be taken down. What do we define as harmful content? There are some extremes that we can probably agree on. Child sexual exploitation material is pretty universally agreed upon as a harmful online content and objectionable. And there are other areas, but in many instances, hate speech and harassment isn't always straightforward. As you even implied in the very beginning with respect to what's going on outside Christie's window, in some areas, people would say that has to stop, and in others they wouldn't. I think you have to look at the content itself, at the context, at the local laws and the ethics and values surrounding whatever that speech was. They all have a bearing on whether something should in fact be taken down. And of course, in the United States, we have freedom of speech, and the dividing line between free expression and unlawful hate speech is not always so clear. So, and then if you go into different parts of the world, of course, especially where there's no free speech concern, you're going to have very different views. So I think thinking about this globally and understanding kind of what we want to do globally is very, very difficult. In addition, words and phrases can have entirely different meanings that could be either perfectly acceptable or perfectly unacceptable in different regions and cultures. One obvious example, a picture of a naked breast could be pornography, or it could be a woman breastfeeding, the latter of which is completely allowed on many platforms. So I think, defining what is objectionable content is very, very difficult. And if we can't agree on what it is as humans, it's going to be very hard for us to program machines to identify it. So that's number one. Number two is accuracy. Of course, if we are going to use AI, we want to ensure that it's accurately reflecting what we've asked it to do. And misinformation, bullying, harassment, that can be near impossible for a computer to detect because of the fluidity and variancy in human language and expression. It's very difficult for AI to be used reliably across different cultures and contexts in these kinds of areas. And it's highly dependent on training data. So developing sufficient training data is key, and I think difficult in these as we stand today. It's difficult to develop, and the access to what we do have as training data isn't democratized. It's largely in the domain of a handful of governments or some extremely large companies. and it's not available broadly. And the tools that are being developed primarily focus on the US and the EU, and they're not thinking broadly about that global impact in those areas where these kinds of tools could be abused. So I think that's another issue. Even for information that we agree is harmful, let's take the child sexual exploitation material that is pretty well defined, and there's relatively universal agreement on its harm, and there's a lot of data. It's still very hard to appropriately train algorithms for a couple of reasons. First of all, the data is, for the most part, illegal to possess and access. So you can't actually train on the data because you can't access it. Second of all, it is hard for the machine, as I said, to distinguish between that kind of material and general nudity, like baby in the bathtub photos, or even adult pornography, which is allowed in many instances. So training a machine to distinguish what is acceptable and unacceptable isn't straightforward. It's not so simple to just give it a couple pictures and go from there. Another complication, of course, is that people learn to avoid detection. Once they understand the rules, they figure out what they can and can't say, and then they work around that. So we know there have been white supremacist groups that use different names of companies or the like, in order to replace different ethnic slurs and avoid detection by algorithms. An algorithm is not going to catch it if they start using a different word that is typically not harmful. And we know that groups that are kicked off one platform can just jump onto another platform in many instances. This is a kind of dovetails to a slightly different conversation about whether regulation at the platform is the only approach and whether we should be thinking about regulation at the infrastructure layers. And we've seen that in some extents, sometimes after the fact, where, for example, a cloud hosting platform or company might take something down after something's happened. So we see that you can regulate at different levels and different layers, and that's also an important thing to consider, I think. And then, of course, again, meanings of words can evolve and change rapidly from something that was acceptable to something that is no longer acceptable. So, someone selling a full batch of special treats might be selling Rice Krispie treats, or they could be selling drugs, and the AI is not necessarily going to be able to determine that from context and pictures and that kind of thing. So I think even if we agree on what should be taken down, the ability of AI to accurately do so is questionable. Third, I would talk about the bias again that the others have mentioned. Algorithms are only as good as the people who create them and the data they're trained on, and people bring their own cultural and personal biases as they're doing so. And so that's going to prioritize what the AI looks at and how it does its work, and potentially could further marginalize and censor groups that already face disproportionate prejudice and discrimination. So that's of concern. And lastly, again, I would touch on the transparency and accountability. Of course, there's fundamentally little insight into how algorithms are coded, how they identify correlations and make decisions, how they're trained, how reliable they are. This could be because companies want to protect their trade secrets or because they just fully don't understand it themselves. But for whatever reason, we don't have enough transparency and accountability around AI. So I think that's a huge issue. So while AI, I would say, is a great step forward in terms of helping rid the internet of harmful content, it alone is not enough. We have ways to go in terms of all of these challenges. And I think, in dealing with the failures, we have to understand and acknowledge them. We have to talk openly about potential solutions, and we need to be transparent and accessible in terms of fixing our mistakes and recognize that the technology is moving so quickly. And it may be that, in a couple of months, we're in a better place on a handful of these things, but we always have to be upfront and recognize what we can't do and where our problems are and figure out how to minimize those. So necessary, but not sufficient is my bottom line.
Terrific, thank you. That was a great rundown of some of the issues that AI content moderation raises. I'm reminded of the Nirvana cover, of the album that launched Smells Like Teen Spirit. There was a baby in a swimming pool, and his private parts were exposed. I have to say, I didn't find it objectionable, but I've seen recently many people, and I'm sure even at the time, some people found that objectionable, but the question is whether or not that is child sexual abuse material. And I think that's, it wasn't depicting it, well, there's been discussion with the actual baby as he's grown up. So I've actually read the story about the baby as well. Now an adult. I don't think it was abusive at that moment, but there's a question. So that issue of, identifying whether or not something is CSAM and should be banned or not is a complicated and very much contextually based, but also one that I don't know if we polled a room, we'd get the same answer. And especially across cultures, the answers may be quite different. So,
and just to that point, I think I did see, I've read, and I'm sure people have considered it in this context as well, but the picture of the little girl running from the napalm in Vietnam, right? And there's been a whole debate about, it is harmful content, and yet maybe it still should be up from the political angle, right? So I think there's a lot of nuance around this that is not settled.
Exactly. Great points. So Christie, you mentioned the empowering minorities, or particularly kind of including minority voices in the kind of internal toolkits that companies are using. Can you tell us a little bit more about how do you think we can protect marginalized communities, minority communities online that are really bearing the brunt of the worst of the internet?
Sure. So I will say, I think a lot of civil society organizations and minority communities in the United States have been doing a really great job of advocating for these issues domestically. Some of the challenges that we're seeing, because my organization works across 57 of our participating states, so North America, all of Europe, and Central Asia. And in many of these communities, particularly where English is not by any stretch the predominant language or the official language. So when a lot of these harmful posts are actually written or that are posted, it takes Facebook or many other tech platforms a lot longer to recognize and potentially take these posts down, because either they don't have the AI technology that recognizes the nuance in that language, or they don't have the real person's eyes on those posts. As Corin mentioned, there's just so many. So what we've been doing, we've had a lot of conversations with the UN Special Rapporteur on freedom of religion or belief, and it's some work that my department has also been doing. And so a few months ago, we started hosting a series of closed door regional roundtables between tech companies, so including Facebook, but a number of other ones, including Twitter, TikTok, and some others, Google, and local Jewish communities, to discuss the experience of Jewish communities in relation to addressing anti-Semitism online, to assess the efficacy of existing tools to address the harm caused on the platforms, and to identify gaps and opportunities for future improvement. And the goal is for the tech companies to understand and integrate the experience of these communities in the ways that the tech companies themselves address online discrimination, and then to create a technology literacy glossary for local civil society organizations and minority communities to build their capacity to engage with tech companies on matters of policy and regulation. And these conversations have been extremely worthwhile, because for many of the local communities, it's the first time that they've actually been able to share the harms that they're facing, talk about some of the targeting that they experience and the ways in which they experience them. And it's great for the tech companies themselves to understand, here's the real world implications of these things, and is either our AI technologies, our policies, are they fit for purpose? Are they able to adequately address some of the issues and challenges that these communities are facing? So it's been a really great start to a conversation. And as I mentioned, we're putting together a technology glossary so that the local communities themselves can also understand what some of these words mean that tech companies throw around, and certainly probably a lot of people much younger than me are quite familiar with. But you go into a very local community in Montenegro, and they're gonna have no idea what what this means and how to use the language to make a report or to contact a social media platform and just say, hey, this is really not acceptable. So some of the other good practices that we see amongst other organizations and that are out there that mitigate discriminatory effects produced by the use of artificial intelligence include government plans to ensure algorithmic transparency, compliance with human rights law to better protect individuals that may be impacted, including persons belonging to marginalized communities. Some of the other interesting initiatives that are ongoing are the ethics guidelines for trustworthy AI, which has been developed by the independent high-level expert group on artificial intelligence set up by the European Commission, the OECD principles on artificial intelligence, the G20 AI principles adopted by the G20 leaders in 2019, and the European Commission's proposed regulations on artificial intelligence as well. So there's definitely lots going on out there. A lot of it is very European centric. So it'll be interesting to see how other parts of the globe, maybe the global south, are also engaging in these topics. Because certainly the harms are not localized just to the United States or to Europe. So I think it's a great start, and certainly more needs to be done.
Great, thank you. Mukund, I want to come back to you. Christie mentioned the various proposals for AI regulation, at the European level, but going back to content moderation directly and social media regulation, we've seen proposals at the state level in the United States. Can you tell us a little bit about those? I know the EFF has been critical of some of them.
Sure, yeah, I can talk about a couple. I mean, there's one from my home state of Texas to regulate what social media platforms can do in terms of regulating content. And then a similar one in Florida. Both are facing legal challenges right now, challenges that EFF has filed briefs supporting that I've helped with. And they're both very flagrantly unconstitutional and they're not going to go into effect. I mean, I can almost guarantee that. The Florida one has been blocked. That's on appeal right now. The Texas one would go into effect on December 2nd. I would be shocked if the court did not stop it from going into effect. And they both purport to tell large social media platforms, here's what you can and can't do with content on your platforms. By their terms, the Texas one would say social media platforms cannot moderate content on the basis of viewpoint or geographic location. And the Florida one says that you can't, the Florida one would basically favor the speech of electoral candidates over ordinary people and restrict the ways that the social media platforms can regulate that content, that speech. And again, as I mentioned in both cases, I mean, the First Amendment does protect the right of social media platforms to host whatever content they do or don't want to. Within, there's always some speech that falls outside the line, but it's on the very extreme end. And something written as broadly as a platform cannot regulate content on the basis of viewpoint, runs directly counter to what the First Amendment says, which allows people, again, whether you're a person hosting your own blog, whether you're a newspaper, whether you're a social media platform, to create the kind of platform they want to. I do want to just throw out there, I mean, I hope this was obvious from what my opening remarks. I'm not saying that I love the fact that Facebook is moderating content or Google or whoever else is moderating content in the way that they are. I think they've made, you can just go down, we could sit here for hours and talk about all of the mistakes they've made. And my co-panelists have pointed out some of these issues, both on the taking down content incorrectly and leaving up content that maybe they should be taking down. But still, it's important when we talk about how to solve these problems that we still keep in place some fundamental rights and guidelines. The Texas law, for example, and both of these laws are premised on the idea that American conservatives are a marginalized group. They are the silent majority and they're being oppressed by the liberal big tech companies. A law like HB 20 in Texas, which says you can't discriminate on the basis of viewpoint, means that if you run a successful social media platform or news website potentially that has a social media aspect for conservatives, and you decide you don't want to host liberal viewpoints, then you're going to be violating the law. And that's why ultimately, I mean, this is just about fundamental freedoms that I think internet users need to have in order to create communities online. I mean, ultimately, when we're talking about the promise of the internet and the promise of digital technology, it's supposed to be about interconnection in a way that's interconnection and creation of digital stuff that should be so much easier online than it is in the real world. And I think that when we're talking about whether it's government regulation or the bad things that these companies are doing, that's the promise that they are failing to fulfill, that ultimately internet users are entitled to. And I would just throw out there as a more general proposition that, I think a lot of the things we're talking about, we're talking about big American tech companies and the power they have over a global technology. We're talking about reforms. Christie mentioned, I think a lot of the reforms and work that Christie is involved in is really important. She did also mention that, some of this stuff is EU centric. And we should look, we should hope at least that the global South would have a voice in a lot of these conversations. The reality is that they don't. And we have to have, if on the one hand, I'm someone who believes in the power of the internet to give voice to people and to decentralize conversations and politics. On the other hand, it hasn't worked out that way in a lot of ways. It's almost a premise of these conversations that we want nicer big American tech companies. We want to create model reforms that other places in the global South maybe can follow. And you think about, I often think about, I'm not a TikTok user, but like that's the new platform on the scene. I don't think it's a coincidence that that platform has arisen in the context of China as a new powerful world power that has invested a lot in tech. So you can kind of see how these trends, how this control over tech and social media follows from other types of power. That's why I don't have any, this is something that I'm also wrestling with as a lawyer who's kind of entering the space and wants to do good work. I think on the one hand, we absolutely need to talk about reforming these companies, reforming these practices. On the other hand, I think it would give up on the promise of the internet and these digital technologies if that was where the conversation started or ended, because that obviously will not go all the way.
Great, thanks, Mukund. I'm going to come back to you in a second, but I want to remind the audience that please feel free to put your questions in the Q&A. Your question will get answered because we have no questions in the Q&A queue as it stands right now. But Mukund, I'm going to come back to you quickly. You didn't mention my favorite part of the Florida law, which was the theme park exception. So in other words, basically any social media platform run by a company that owns a theme park would be exempted from the law. So a straightforward case of viewpoint discrimination in favor of Disney and Universal Studios. What do you think about that?
I just have to confess, like I haven't been a lawyer for a very long time. And so I must have missed I took First Amendment in law school. I must have missed the class where we talked about the theme park exceptions to the First Amendment. So that's why I didn't get into that, is because I didn't want to speak on a subject that I'm not an expert on. But candidly, it's the reason I didn't mention it is that it's the cheapest of cheap shots to take at an unworkable law. And I wanted to give at least the law some, to take it at least at principles that I think, because Texas does not have a theme park exemption in its law. Its law is slightly more workable, but still does not really make any sense in practice and still violates the First Amendment. And so, yes, that's yet another reason why I'm very confident the law will be struck down. I think one of the reasons it's important to talk about the general principles is that those, again, there's this idea that is popular among, at the very least, conservative state governments that they need to protect American conservative speakers. I think we may continue to see efforts like this to pass unconstitutional laws that violate the First Amendment that may be better crafted than Florida's law. Just getting into the kind of legal practice of American courts, they will sometimes sever or separate unconstitutional parts of laws and let the rest go into effect. So a court may say, okay, theme park exception, no, that's not in the First Amendment. We're going to have to put that aside. Now let's look at the rest of the law. And so that's where kind of these more general principles become important.
So we have a question, and I promised anyone submitting a question that they would get answered. It's from anonymous attendee. I just want to point out that in many countries, real names are an obligation when you engage in social media. And so just this very fact that you are using a platform and remaining anonymous is a privilege in the United States. We haven't, the anonymous attendee writes, we haven't heard much in this conversation about the business model of the social media companies. Is this a root cause of the problems caused by the companies? And if so, how do we address the cause rather than only focusing on symptoms? Anyone wish to open up the conversation? Corin.
Well, I guess I would say that I appreciate that question because there is a business model that we are ignoring, right? I think, you know, one of the things we've talked about a little bit in lead up to this conversation is corporate ethics and what role they play. And I think, you know, there's always a role for ethics everywhere and everything we do. And on the good news side of things, many and most corporations have corporate ethics. But on the less positive side, we have to be realistic about those, right? There are core business reasons that these corporations exist. They exist to make money, and this I don't think is shocking. And so when it comes down to looking at the ethics versus kind of major action against financial interests, I think we're going to see the ethics move to the back burner, and that is, again, not surprising in my mind. These companies are in business to make money. We know that. And so I think we have to weigh and understand kind of what the bottom line is. And I that isn't to say I think very much that corporations want to do the right thing here. First of all, it's hard to know what the right thing is, but I think it is also, again, you know, very hard when they're beholden to shareholders and the goal here is to make money, to have that outweigh ethical principles. And so, you know, we've seen in some cases, not only unwillingness to enforce maybe sometimes their own terms of service, but an active inability to do so, where you have end-to-end encryption, which provides all sorts of benefits, but also makes it virtually impossible for a company to in fact enforce its own principles because they can't see what's happening in some of their spaces. And so they only know to take something down or to remove anything because someone, a party to the conversation, has raised it. And so I think, you know, we do have to be realistic in terms of what these corporations will do on their own versus what the law might require. And that's why I think it's going to have to be some sort of combination. As we're seeing and as we're talking about, the question is what that law might look like. But I think there is a bottom line that we have to be cognizant of. I don't think that's a surprise. And I don't necessarily think that's a terrible thing. We just have to recognize it and work within it as we do in many other contexts. I do want to point out in response to some of what everyone else has said that there are lots of AI ethical principles promulgated. They're fantastic. There are global ones, there are corporate ones. And Harvard actually put out a piece last year that compares 36 different AI ethics principles documents and gives you sort of the core of what they say and how consistent they are or not. So I'll drop a link to that in the chat, but it's a fantastic document if you haven't seen it, and it helps you kind of navigate, at least from last, you know, up to about last year, what those documents look like, how they're consistent, how they apply. So I think that's a great tool.
So I just want to, raise the issue of Telegram. Someone mentioned a number of different platforms, but the one that really skates under the radar is Telegram, which, as far as I can tell, doesn't really have any ethical principles at all. And so, so it's a pretty shocking platform from the design on up. And so I just, I think more scrutiny needs to be placed on Telegram and how it's being used and abused. It's being used by people doing human rights, but it's also being used by white supremacists and neo-Nazis across the world. So it's a favored destination for a variety of communities, and it has, as far as I can tell, really almost no content moderation hopes, not even the encryption concerns that Corin's talking about. It's really, so anyway, in that it also raises the question of what exactly is the business model problem And so, I think sometimes we reach for a simple solution when I think the story is actually far more complicated. Okay, so Christie, I think you wanted to join in on this issue.
Definitely. Maybe I can, I see a question relating to multilateral cooperation, which I'm happy to quickly address, and just say that this is definitely something that, that my organization is very much interested in. We partner very closely with our United Nations colleagues, specifically the folks from the UN Office on the Prevention of Genocide, as they are the folks sort of tasked with the UN Plan of Action on Hate Speech. And so, yes, it's very much something that we are looking at from a national, regional, and sort of global perspective on how to address these issues, and to really look at some of the underpinning factors, looking at hate speech, the exacerbation of violence that can then occur offline and in real life, to hate crime. And then obviously, as some of the escalating factors might even turn into armed conflicts or mass atrocities. So, that spectrum of escalating violence is something that we all take very seriously. And because our individual organizations work on different aspects of those, being able to partner closely together is something that we take quite seriously. And then I saw another question down at the bottom, so I'm happy to just make a very quick comment. As I mentioned, that the AI technologies have been prone to bias and discrimination on a number of different factors. And this can also be exacerbated when the application goes beyond the identification of individuals and uses emotion analysis and personality risk assessment, for example, in the context of criminal justice, counterterrorism, and border controls. So these algorithmic decisions in criminal justice and counterterrorism contexts can affect the right to liberty, the right to fair trial, as it can impede the defense that are subject to algorithmic decisions from examining and contesting their reasoning if it's done by a computer, basically. So that's just all I'll say on that, and happy to turn it back over to the others.
Would anyone else like to speak to the question raised by Margarita Melillo? I hope Melillo, sorry about that. Do you see any possibility of multilateral cooperation in these matters, or does the trend seem to be national or regional action? And is that enough?
I guess I would just quickly say I absolutely think multilateral cooperation in this area is critical. I think we see, again, the difficulties with that are the differences in views and context and cultures and all that. But I think we're always stronger when we're joining forces globally and thinking through these issues together from many different perspectives. And these companies are global companies and they're operating globally. So I think we lose something if we don't do it together.
So last thoughts from Mukund first.
Sure. I mean, I think one, I'll just plus one what Christie said about, the risks when it comes to government AI, the threat to liberty. I'm someone who works for a criminal defense organization and takes that very seriously, especially when it comes to policing and incarceration. I'll also say, I mean, the harms are kind of there across the board. They just differ. I mean, content creators online who use, those platforms for their livelihoods, they face a very real threat when social media platforms use problematic and flawed AI tools to take down their content incorrectly. That threat to livelihood is also very serious, and so I also wouldn't want to downplay that. And I'll just close with one comment actually on the first question about the business model, because I think this gets. And I would put it in the context of just a more general thing about what the internet should look like, which is a free place for users to do things that they want to do. And it's a force of democratization that I think has really been corrupted by the presence of, not just capitalist business models that we may not like, but, for one, monopolistic practices that I think does require clearly some legal action to be taken. But also more generally, I mean, there is no law or reason that says that our internet has to run on the basis of advertising, on the basis of surveillance, and one where we have these large walled gardens where big American tech companies set the rules. So, I on the one hand, I'm hesitant to say that we should say these business models are illegal and we should outlaw them, because I think that, then you're just empowering another big institution, the government, to come on the scene and make those decisions. On the other hand, we do, like I said before, I think we do have to think about how do you empower ordinary internet users, including in the global South, where clearly there is less power, to do the things that make the internet the great place that it has the potential to be. And I think, it's not somewhere where I work, but I see antitrust action in the US as like one important place to break down some of those barriers. But clearly, I think some of the answers are going to have to come from people that aren't me and people who are actually from the global South and from these communities.
Great. Thank you so much, Mukund. I'm going to turn it over to Catherine Amirfar to close this out and bring us to the next panel.
Thank you so much, Anupam, Christie, Mukund, and Corin. What a lively and very, very timely discussion. And even if we can't hear everyone's applause, obviously, please know that I speak on behalf of the society and everyone listening when I convey our highest appreciation for you joining us today. So thank you.